So what case from your attorney days kind of sticks with you now that you've been a judge for a while?
So I worked with a corporate firm and did a lot of regular run-of-the-mill corporate work, tax work. But at the time when I was a lawyer, the firm that I worked with got involved in what's known as the HUBCO litigation, which basically was an arbitration dispute back in the day, which looked at the arbitrability of a dispute before whether it could be taken to court or whether it was to go to an ICC arbitration. And the parties at dispute were the government, WAPDA, which is a government agency, and HUBCO, which was an IPP, an electricity production company. And it was a big case at that time because the whole issue was that the two parties had a dispute, and the question was whether that dispute would be decided by the courts in Pakistan or whether it would be arbitration. It was a big dispute, one of the biggest cases that I had done. It's something that I can't forget because it brought in a lot of media attention, and it also had a personal effect on me because I was to get married that year, and my date for my marriage was all based on the timeline and the schedule of the case. So I literally had to find a week in which I could get married while attending to the case with the team of lawyers that was working.
Well, being that you're the first female justice on the Supreme Court, I imagine it was difficult to get to that spot. What were some of the challenges?
Yes, it was definitely difficult. It was a challenge. I think. I was nominated by the Chief Justice, and there was supposed to be a judicial commission that was to consider my nomination. But there was a big disagreement on whether or not I should be appointed to the Supreme Court. And the primary argument that was being used against me was that we look at things in terms of seniority. So I was the fourth senior judge in the High Court. And the argument being used against me was that I'm not the senior most, I'm not the Chief Justice, hence I should not be brought onto the Supreme Court. The argument on the other side, which my Chief Justice at that time stuck to, was that seniority is not a principle that we've generally followed while bringing in judges into the Supreme Court. So there are over 40 some judges that have come into the court without following the seniority principle. And the judges that came before me, at least three before me, were all judges who ranked at the fourth or fifth number in terms of seniority. So it was a big issue. The entire country was talking about my nomination. I was being discussed on television, whether the seniority principle should prevail. The gender, I think, had a role to play in it as well, because there had never been a woman on the Supreme Court. We're the last country in the South Asian region to appoint a woman to the Supreme Court. And in a way, it's a bit concerning that it took 75 years to nominate a woman to the bench. And at that time, the conversation tilted in a direction that it had never tilted until the woman was being appointed. So it does make me wonder whether gender played a part. And the reason I say that is because gender is there are not many women judges in the High Court and Supreme Court. We're less than 2%, given that we represent half the population. 50% of the population in Pakistan are women, only 2% on the bench. So that is something that we have to look at and we have to think about. And the fact that when it came to the appointment of male judges, it just happened as a routine and course, but when it came to the female judge, the entire conversation centered on seniority as opposed to merit, as opposed to anything else. So anyway, it took 6 months, and then again, my nomination was brought up again, and I managed to get onto the bench by a 5-4 vote in my favor.
2% of judges, you say, are women in Pakistan, but the attorney population is more than 2%, right?
Yes, the attorney population is more, I would say, around 25, 26%. The courts are a very difficult environment. They're not very conducive for anybody, but for women in particular, not very favorable to women in general. So it's not an environment where you easily encourage women or where women would easily go. It's a very male-centric environment, and it's an environment where primarily, it's how the man thinks. And I often say to people that I live in a country where basically the laws, the rules, and the policies are made by men. And so they tell you how to think, they tell you how to respond, and they basically tell you how I should react when a decision is made about my gender. And in a way, I kind of like come in with this new gender perspective, which I encourage a great deal, that we have to look at this new narrative, which is the gender perspective. Look at things from the woman's point of view, look at how she will respond to things. Hence, the two-finger virginity test, which was a very invasive test done on rape victims to determine whether or not they're raped, without relying on DNA testing or any medical evidence. For a very long time, we were looking at this invasive two-finger test. And it took a woman judge to turn around and say that this test makes no sense at all, and to strike it down and to require that the law look at DNA testing or medical testing, whatever made sense medically. So I think it's important to keep this perspective in mind. It's a very male-centric society. And just to give an idea, you get, when you become a judge, they're told, there are a whole lot of rules and regulations and traditions that I was told. Essentially, I was told, there's no gender to a judge. And I thought, that's odd. For the longest time, the judge is a man. And now that I've become a judge, I'm told that judges have no gender. It's like, no, I think we do have a gender, and my gender I bring with me into the court.
Does gender come up in surprising ways for you? Obviously, with the virginity test that you're talking about, it's kind of obvious that would play a role. Does it pop up otherwise in ways that surprise you?
Absolutely. It pops up in ways that are surprising, and it also comes up in ways which are sort of routine, which is part of a thinking, a mindset. And one of my primary roles, I feel, that's my calling, is to try and help break down that mindset and explain that this is not the law, this is not the way things are supposed to be. This is just a way we've evolved as people. So in custody cases, there is a belief generally that mothers lose their custody of their children if they get married a second time, which is incorrect. So I've given a ruling to say that that's an incorrect understanding of the law. Mothers don't automatically lose custody of the child. There's only one factor in Pakistan that governs custody, and that's the welfare of the minor, the welfare of the child. Nothing else matters. And similarly, another interesting case that we did was harassment at the workplace. So before I became a judge, my colleagues ruled that harassment at the workplace is primarily sexual. And obviously, you can imagine where 50% of the population is women, everybody was absolutely horrified that it's not just sexual. Harassment at the workplace involves different forms of harassment, which can be a look, which can be a tone, which can be a message that you're given. So luckily, that judgment was called in review. So that means that the bench sits again and looks at the judgment. And I was lucky enough to be a part of that bench. And one of my colleagues who sat on the bench with me told me that we're going to hear the case, but I'm not going to change my mind. I have already given my opinion, and I'm not likely to change my mind. But I know you have an opinion on this, so I'll allow you to sort of share your draft with me, and let's see what happens. I took that as a challenge. I took that as a very big challenge. And I said, all right, now my objective is to convince my colleague that he got it wrong. And I'm happy to say that I was able to do that. I wrote the judgment, I gave it to him, he read it, and he came back and he said, Ayesha, we did get it wrong. We didn't think about the things you wrote. And that's the difference that I like to make.
That's wonderful. Can you tell us a little bit about how cases move through the judicial system in Pakistan?
So there are 3 tiers of courts. There's the trial court, then there's the high court or the appellate court, and then the Supreme Court. And cases originate primarily in the trial court. So they can be of civil or criminal nature, and they originate there. From there, there's a right of appeal, and that appeal ultimately will bring them into the high court. And from there may be another right of appeal which will bring them into the Supreme Court, or there will be a leave petition where you will bring a petition to the Supreme Court to ask if leave can be granted on a point of law, and if the court is willing to consider that point of law.
That actually sounds a little similar to the United States.
Yes.
So we are sitting, for folks who are not attorneys, we are sitting in the appellate court, which I refer to as the meat in the sandwich of the judiciary, here at the Court of Appeals. So you start in the trial court, you move to the Court of Appeals, and if you're granted leave, then you go to the circuit court. Okay. Historically, the United States Supreme Court has tried to stay above the partisan fray. No further comment. Is the judiciary in Pakistan able to remain isolated from politics?
I think,
Or is that just unrealistic?
I think, let's put it this way, that generally the belief is that that's unrealistic. That's not my opinion. That's just generally the belief.
People are saying
that it's unrealistic, and yes, there have been ups and downs, but by and large, I think it's important to keep both perspectives in mind. Pakistani courts are undervalued for the amount of work that judges do and the kind of jurisprudence that's evolved out of that court. They're undervalued, and not a lot of attention is paid to them because we're not good at really projecting ourselves that way. And so, like, for example, in environment cases, we've done great work. And since the 1990s, we've been declaring rights in the field of environment, rights which never existed. Our constitution doesn't recognize environment rights to water or to clean air, but the courts have recognized it and pushed. Happy to say that some of the judgments now, because I think social media and easy access, some of the judgments do circulate around, and I've had the privilege of having one of my judgments on arbitration, which basically looks at challenging a foreign award in the domestic court, in which I ruled that you cannot challenge foreign awards in a domestic court on the grounds of public policy. The window is very small and very limited, and I looked at cases from around the world, and that judgment has been recognized by judges in Canada and in Europe, who actually reached out and sort of appreciated the work. And it's nice to know that you're recognized and that your jurisdiction is recognized. So for all the politics and so on, there's also a good side to the hard work that goes into being a judge in Pakistan.
I'd like to talk to you a little more about the environmental rights that you mentioned. You said that the court has recognized a right to clean air and clean water.
Mm-hmm.
How does that get derived?
So a petition can be filed in the court and say the litigant says that I live in an area which is close to a mining district and there's a lot of pollution, and this work has to be stopped or they have to relocate. And the court, because you're a constitutional court, judicial review, the High Court, the Supreme Court can look at the matter and can say, because this litigant has the fundamental right to life, and that fundamental right to life includes the right to clean air, and because there is a right to clean air, the government is obligated to ensure that he gets his clean air. And so you can move things around on the basis of declaring these rights. And we've declared clean air, we've declared clean water, even we've gone under the terrain and said clean, aqua water. We've lots of basic rights which circulate around environmental law. We've looked at the regulatory framework of the environment regulator, the EPA, and also worked on how due process works in that. So there's a lot of pollution in Pakistan. There's a lot of work that needs to be done in the world of environment and even in climate change. And judges have played a good role in doing so.
So let's talk a little about logistics. Do most of the cases that come before you get oral argument, or do you decide them just on the papers?
Every case is heard.
Oh, wow.
Every single case is heard. We hear from 10 to 15 cases to 30 cases a day, and each case is argued, and in most cases, I would say 50% are decided that day, and some cases are part heard, they continue, some get adjourned for one reason or the other. But generally, the Supreme Court does not welcome adjournments compared to the other courts.
So in the United States, courts have various levels of public access. So for example, this court has a YouTube channel where everybody can watch arguments streaming live, or it's recorded for posterity. They can watch it anytime. It's very accessible. Other courts just have an audio feed. How does that work in Pakistan? How does accessibility work there?
So courtrooms are public areas. Anyone can walk into a courtroom and can hear a case. So far as doing live streaming, this is something new. The Supreme Court started it last year in one court as an experiment and is working on now expanding this facility. And the other courts, the high courts and the trial courts, are all working on making themselves accessible by having virtual hearings available, as well as we don't have YouTube channels at the moment, but we are working on it. It's sort of work in progress.
What do you feel the judiciary should do for law students and young lawyers as mentors? What is the role of the judiciary?
I don't know directly. In our system, we're very sort of conservative and traditional, so judges don't really interact a lot with law students. We have law clerks in the Supreme Court, but I think interacting with students, getting people to understand what it means to be a judge and the onerous responsibility of being a judge, the kind of work you have to do. I would like to see more young people wanting to become judges, more women becoming judges. And that can only happen if I'm able to talk about what my life is about and how I do the work and how you deal with challenges and how you take the opportunities and you work with them. So I think conversations and lectures are important. I think there should be openness as well. Everything shouldn't be closed door. So people should be able to have discussions with judges. You have to respect the line and the boundary of what can. My point is, this is what could have been added in the judgment. Let's have a discourse, a polite conversation, but let's not be nasty and critical. That's not how it works. So yes, everyone's entitled to say, this was a good judgment, this judgment fell short in this way, there could have been more discussion in that way, but there must be a way to do it. And I think that's the role that can be played between judges and law schools and students, where there's more interaction so that the level of conversation and the discourse improves. And there's more discussion, and I believe in generating a global South narrative, because I think it's time that we have our own narrative where we look at what's happening in our country and look at how things are working out. And so you need for the academia, the students, to understand what's happening and how the judges are thinking and where the problems lie. So that would be another area where that would be good discussion. I, for one, have started citing good academic work in my judgments to encourage the academia to write on issues that are relevant. And I'm not the expert on everything, so when I need an expert's opinion, I do go searching for good academic work.
What do you mean by the term global South narrative?
So there's the global North, so that would be the experience of, say, the United States or Europe, and the global South would be the experience of Asia and the different parts of Asia. So when I speak of a global South narrative, it would be the South Asian narrative, where there's a lot of similarities in the way we look at things. And it's important for you to have writings that come out of that narrative. So if I'm looking for something related to gender, gender-based narrative, or anything related to looking at how courts have evolved over time in pronouncing rights in favor of women, I'd like to see what's happening in the global South as well as the global North, because the people of Pakistan may not be able to relate to what's happened in the global North because the experiences are different, but can relate to what's happening in the global South because that's a narrative that's closer to home and the conditioning is closer. And that's a narrative that's not really very evolved or developed. So I think it's important to develop that narrative.
So the World Justice Project has ranked the Pakistan judiciary number 129. The United States is not at the top, by the way. We're like at 26, so this is not a looking down our noses at anybody. But Pakistan is listed at number 129 in adhering to the rule of law. What is your reaction to that?
So the first reaction is that it's not all about the judiciary. It's the rule of law, and it has different components. And the judiciary comes in the civil jurisdiction and criminal jurisdiction. And there, primarily, the reason why we have low ranking is delay and the inefficiencies of the system. So again, I think it's important to see that it's not primarily about the judges and the work of the court. It's about the systems and the delays in the systems and the general justice sector. It's also, of course, about the delay in rendering judgments and the lifetime of a case. So it's the inefficiencies of the system, but it's not primarily about the judiciary itself. So we rank poorly in the rule of law index because probably the biggest challenge for Pakistan today is enforcement. We make laws, we make policies, we give judgments, but we're very poor in enforcement. We don't enforce, and we don't have good enforcement mechanisms, and we don't really think about the enforcement process. We don't work based out of research and data. So we're not really monitoring, reporting, and looking at, you can have a great policy. For example, in gender, there'll be a lot of talk about equality and equal opportunity and how we must ensure that the women of Pakistan become these great, women who represent their country all over the world, who are educated. But we fail miserably when it comes to looking at all the components that make up that discussion. And the reason is that we don't enforce the policies. So we have great policies, we may have good laws, but we're not enforcing them. We're not going back to look at where have we actually taken the steps. So I can give an example in climate change. There's so many judgments, clean air, clean water, but where's the clean air and where's the clean water? And that's primarily because enforcement. So it's a big challenge. So I think focus point for me as a judge would be to focus on enforcement mechanisms and to look at, once policies are put into place, judgments are rendered, how to enforce them.
So if I'm hearing you correctly, you're saying there's sort of a ceiling on the rule of law, and it's kind of what the rest of the government is doing.
It's a combined system in which maybe the courts have a small role to play, but a lot of it is with reference to government efficiency, corruption, enforcement, law and order. So it's a collective. There are many elements. I think there are 12 or 13 elements that go into this index. And on that index, yes, we don't do very well on that index.
So you mentioned that cases can really linger a long time. A contact of mine told me they can last decades. Is that true?
That's true. That's true. We're a highly litigious country. We litigate on everything. And when you litigate so much, there's a lot of backlog. So there's a lot of backlog in the trial courts, and then in the High Court, and even in the Supreme Court. At the moment, I think the Supreme Court backlog is somewhere between 55,000 cases, which sounds like a lot. But when I look at it from my point of view, we hear 15, 20 cases a day. When I was in the High Court, I was hearing around 70, 80 cases a day. I mean, how much more?
You're going as fast as you can, clearly.
You are hearing, you are deciding matters. The process is slow. What we need to do is build in more efficiencies into the system. And we need to build in more efficiencies. We need case management. We need a more scientific approach to how we handle cases and what we do with our cases. But a lot of these cases originate in the trial court. So that's heavily loaded with a backlog. And that system needs an overhauling. And then the same, it goes into the High Court. That system needs to be overhauled as well. I think the last place I would look at would be the Supreme Court, because the Supreme Court is really looking at cases that come from the other courts. So you really have to fix your systems and improve the efficiencies of the system. So cases can take a decade. They move from court to court. So in the trial court, judges get transferred regularly after 2 years, 3 years. So everything that they're hearing kind of stops. And then a new judge comes and has to pick up. So that could be one reason. There are delays in summons and notices. There are delays because too many applications are filed in one particular case. So every
litigant and their lawyer will be filing miscellaneous applications, and each application will take time. Cases that shouldn't be brought to court are brought to court, and the limine disposal is less. And generally, judges who dispose of cases in limine, they're not very popular, because it's felt that, now that a case has come to the court should hear it.
What does limine mean for those of us unfamiliar?
Limine means a case that should be disposed of, dismissed at the very first instance. It does not belong in the courtroom, so it has to be dismissed instantly. So there should be cases that are dismissed instantly. But like I said, we're litigious, and I think one of the reasons why the High Court and the Supreme Court are inundated with work is because of the inefficiencies of the government. Again, judicial review of government action, that leads to more litigation from I haven't been paid my salary, I haven't been given my pension, I've not been promoted, I don't have electricity, they've not given me a gas connection. This is routine work. This is absolutely routine work. I've not been paid by a government contract. I'm a government contractor. I've not been paid. Even pertaining to educational institutions, my grades have not been released. I've unfairly been failed in a subject. So it's a lot of work. And I think a lot of it goes to, if someone were to sit and analyze it and research it, maybe it goes to trust and confidence. If the public doesn't trust the system, doesn't have confidence in the system, because they don't think that the system is run on a set of rules, then you tend to litigate. You tend to litigate on a lot of things. And also it's inefficiency. I mean, at this point, we should have pension, salaries, promotion issues.
You shouldn't have to go to court to
vindicate those. And it should be the exceptional cases, not the rule. We get a lot of rent matters coming, so you have tenants and landlords, a lot of family matters. Unfortunately, it's one of the biggest litigating factors, family matters. Divorce, settlement, custody, it shouldn't be there. And property. Property is a very big litigating subject matter. A lot of disputes on property.
Do you get a lot of family matters at the Supreme Court level?
We get a lot of family.
Really?
Yes.
That's very interesting.
We get a lot of family matters.
Switching topics, do you have a favorite judge in Pakistan, either historically or...
I have mentors, people who I think are good, they've mentored me, or they were good examples. But I think as a judge, it would be unfair for me to comment on anyone in particular.
What is your hope for women in the legal profession in Pakistan?
Equality. I think it's equality. It's not just about more women in the justice sector, more women lawyers, more women judges, but it's about giving substantive equality to women. It's about ensuring that women get their due share. And again, I give an example. Inheritance for us is God's law. It's not man-made law. So the law of inheritance on how property is to be distributed is provided by God, and we're supposed to follow it. Yet women, even today, are deprived of their God-given right of inheritance. And even today, we litigate on the fact that women come to court to say that I've been deprived of my right of inheritance. So I would like to see these kind of cases just totally finish. And as people, we must recognize systems and rules and laws. We must respect each other, and we must give people their due. And I would want to see women get their due.
Absolutely. We've saved a few minutes for audience questions, which I think is in possession of Maha. I have one sort of fluffy question that I want to end on, because I'm a huge fan of Lahore. What should we not miss on our next visit there?
The walled city.
Yes.
The walled city. I can
Okay, we did get a question. Why are you not part of the constitutional bench in the Supreme Court of Pakistan? Do you feel sad that you cannot hear constitutional matters in the Supreme Court of Pakistan?
So, post 26th Amendment, like I said, the Judicial Commission nominates judges to the constitutional bench. Once a judge is nominated to the constitutional bench, then there is a committee of 3 judges, 3 senior judges from the constitutional bench. They decide what cases are to be fixed, and they decide which judges will hear the case. So although I am nominated as a judge of the constitutional bench, it's primarily left to the committee to decide whether I should be on the bench or not. I don't have a say in it. And as a judge, I don't think a judge should feel sad about whether or not they're part of a bench or not part of a bench. But I think I would say that there's a lot of misconception that goes out with the role that a judge plays where such decisions are made. So in terms of seniority, I am the 6th senior most judge in the court. And I don't really have a role to play, and I don't have a say on what cases I get to hear. I don't have any, nobody's coming and asking me, what would you like to? And nobody's saying, would you like to sit on this bench, or would you like to hear this case? So since that's not being done, I don't have a say in the matter, and I go with whatever's given to me and what the kind of work that is given to me. I think if I were working towards a more closely knit court, 26th Amendment or not, there should be more dialogue on that. There should be more conversation on that. And judges, all judges are good judges, and judges have their forte of work, what they're good at doing. And so, for example, I've spent a lot of time doing corporate work, of taxation, and a lot of corporate work. All that work has gone on the constitutional bench. So I don't do that work anymore. I do the appellate work, which is rent matters, service matters, family matters, and some tax cases that come through the tax tribunals. We get to hear some those cases. So presume what you need out of it.
We had something similar actually in Texas. They kind of lopped off certain matters that are heard by business courts. Institutional necessarily, it's a class of cases, matters against the state that are not criminal, things like that. But I wonder if that's just like a phenomenon going on kind of globally.
Well, I don't know if it's a phenomenon going around globally, but it's changed the contexture of the Supreme Court totally, and how we've historically worked as a court. But for me as a judge, every case is important, every litigant is important. So I'm not sad that I'm not hearing any particular case. Every case is important, and I look for the challenge in the cases. I like to hear challenging cases, and I like to decide matters which I feel are cases of first impression, where I can sort of help settle the law in some direction.
So didn't the 26th Amendment also increase the size of the Supreme Court?
So not the 26th Amendment. The 26th Amendment didn't increase the size. They brought in another law subsequent to the amendment. We were 17 judges. I think we're now, I've lost count, 26 judges. So they increased the seats to 32 seats. So we can have up to 32 judges in the Supreme Court.
Do you ever hear a case as a whole en banc?
We haven't. We've done it as 17, but no, not.
Like, where do you put them all?
Exactly. That's a lot.
It's a big bench.
It's a big bench. Yes, I'll give you that. So you want to?
Yes, let me read the question, sorry. Okay. We have witnessed judicial activism in Pakistan courts since the reinstatement of late Chief Justice of Pakistan, Iftikhar Mohammed Chowdhury. Why courts, and especially the Supreme Court, why are they silent?
Well, the 26th Amendment has done away with the suo motu powers. So primarily a lot of the activism that is being referred to in this question came out of suo motu jurisdiction. Suo motu jurisdiction means when the court of its own accord picks up an issue and looks at that issue. And this is a jurisdiction that is it's interesting. It's heavily criticized by people, and at the same time everybody wants the court to exercise this jurisdiction. But now post 26th Amendment, there is no suo motu jurisdiction. So it's not that the court is silent, the court doesn't have this power anymore to exercise suo motu jurisdiction. But I think generally, one opinion as a judge would be that systems have to work when every institution does its job. And if you just start looking at one institution to do the job of everybody, then you'll have what's called judicial overreach, or you'll have too much interference in the system. So you really have to get the balance right. And it's important that all institutions do their job. So we shouldn't be relying on suo motu action.
That's so interesting, just that concept. I've never heard of it.
Yes, it's unique to the subcontinent and some other countries, suo motu action.
Very good.
No, that's a bit testing.
Alrighty, how are we doing on time? Okay, I think we are close to time if we want to keep to our schedule. So thank you all for being here. Thank you, Justice Malik. And there is a reception out there. There are drinks on either side and there's food. So please help yourselves enjoy, circulate, meet and greet. Yes, please. Is it okay to take a picture?
Yes, absolutely.
Thanks. Yeah. Let's put the TikTok.